Community Futures Ontario has 61 Community Futures Development Corporations serving all of Ontario. What can a CFDC and the Community Futures program do for your small business? Consider the three-legged stool. It's a solid seat, but take away just one leg and you'll be picking yourself off the floor. The Community Futures program has three essential legs too: economic development, business counseling, and small business loans. Economic development activities advance opportunity for the small business sector within local communities with feasibility studies, marketing campaigns, and skills training to create a job-ready workforce. Business counseling helps small business operators combine their knowledge and experience with sound business management principles and ultimately more success. And it's free. We'll show you the money too. CFDCs can lend a small business up to $150,000 to start, expand, or even reposition. Equipment, renovations, inventory, and working capital can all be financed by your local CFDC. Three indispensable legs of a sturdy stool. That's the Community Futures program.
Bonjour, hello, Annie. Je suis Nicole Fortier-Levesque et membre du conseil d'administration de Phonom, représentant le district de Cochrane, membre des conseils d'administration d'AMO et d'AFMO. Je suis maire de Moonbeam. Il me fait plaisir d'être parmi vous aujourd'hui à l'occasion de la conférence annuelle de Phonom et de vous présenter notre prochaine invitée, Madame Jessica Jaremchuck. Jessica Jaremchuck is the Director, Risk Management Services with expertise in risk consultations and contract and legal reviews, and has been with Intact Insurance since 2011. Jessica is a third-generation Packers fan. Go Pack, go! Thank you, merci, miigwech. Je vous souhaite un bon congrès.
Hello, everyone. My name is Jessica Jaremchuck, and I am from Intact Public Entities, and I've been invited today to talk about insurance and risk and what the environment's like today for municipalities. First, as I just said, I'm from Intact Public Entities, probably used to me saying Frank Cowan Company. So as most of you know, Frank Cowan Company was purchased by IFC, Intact Financial Corporation, in December of 2019. Frank Cowan Company was founded 94 years ago by Frank Cowan and has been a leader in providing specialized municipal insurance across Canada ever since. With the new purchase, we always knew that we'd have to change our name, no longer being owned by the Cowan family and Princeton Holdings. And that time has now come. Frank Cowan Company is now Intact Public Entities. Importantly, for everyone to know, we are still a wholly owned subsidiary of Intact Financial Corporation, IFC. We are still an MGA. There's been no material changes to our operations, same team, same services, same expertise we've always had. Your contacts at the company are the same. Pretty much everything's the same except for our new name. Stay tuned for our new website launch. Our marketing communications team is doing an incredible job. They are transferring, our over 300 Center of Excellence articles and resources over to the new format. All of that's still going to be available for everyone. Really looking forward to it. So keep an eye out for that. And I really hope that I accidentally don't say Frank Cowan Company. This is, I think, only my second time saying Intact Public Entities, so wish me luck. So today I'm going to spend a few minutes talking about today's insurance and risk environment. I usually start all these videos and webinars telling the audience how much I wish we were all together in person, and never has that been more true than it is today. I love getting to visit with you guys up north. It's probably one of my favorite things that I get to do as a part of my job, and so I'm really, really missing that this year. Even though I am talking about insurance, which probably isn't going to make me that popular right now, probably not the most popular person at the conference, I'd still rather be there and see you guys in person. I also want to thank Phonom for having me and also commend them for pivoting to this online format so easily and doing such a great job with the conference. I've spoken to you many times about claims driving premiums. We've spoken about the long tail nature of municipal liability claims. We've talked about the fact that it can take 7 or more years for a claim to reach trial. And all of that time, you're amassing those legal fees and other costs. And how are actuaries supposed to plan for that? Forecasting for 10, 15 years in the future is so difficult to do. How are they to know what a claim will cost 15 years from now? And then there's joint and several liability, an issue that myself and everyone else here has been discussing for years, and the impact that joint and several has had on municipal claims. For those of you who may need a little refresher, simple example to explain. Let's say you have a 20-year-old driver. He's driving his girlfriend. They're going down a class 3 rural road. He's driving too quickly for the conditions and he flips the car. Unfortunately, his girlfriend becomes a paraplegic. Now that family has to make sure that their daughter is taken care of for the rest of her life. Medical care, nursing, fixing up the house to accommodate a wheelchair. Where are they going to get the money for that? They're going to have a lawyer, and that lawyer is going to sue that boy. That young man was even charged with reckless driving. Now, that lawyer is also going to recommend that they file suit against who else? If we were together in a room, I would hear everyone say the municipality, and you're exactly right. That lawyer is going to try and see if they can find even 1% responsibility on that municipality. So let's move ahead. You're at trial. Let's say that the damages have been agreed upon at $10 million. We know that that's low, probably closer to 17, but math still isn't my strong suit. So let's say it's 10 million for ease of math. Let's say that judge hears all the arguments, says to that young man, you are 90% responsible for what happened. You should have 90% of the responsibility for paying for this girl and her costs. So that would be $9 million. Municipality, your records weren't great. We couldn't tell the last time you had inspected that stretch of road. You are 10% responsible, so $1 million responsible. So the boy's supposed to pay the 9, municipality's supposed to pay the 1. But that boy, like many of us, only has $1 million on his car insurance. So after that $1 million's paid, where is that other $8 million going to come from? Joint and several says it's going to come from the municipality. The principle of joint and several is to make that injured party whole again. So they're allowed to collect that damage award from any one of the wrongdoers. Now, the municipality, of course, can then subrogate. It can go after that young man for that $8 million that's owed. But you and I both know that you can't get blood from a stone. You'd spend more money in legal fees trying to get that $8 million than you would ever see. Now, let's take that exact same example, but take the young woman out of the scenario. So you've got the boy, he's driving recklessly, flips the car. He has a head injury. Now, he decides to bring a claim against the municipality. He's going to allege that they didn't properly inspect the road, or maybe that there's a design issue with that road. At Intact Public Entities, we have, decades and decades of claims experience with municipalities. So when our claims team takes a look at a fact scenario, they usually estimate how much responsibility is going to be apportioned to the municipality, to our client. We are repeatedly seeing claims where we would have, 10, 15 years ago said, okay, we think that the municipality may be found, 10, 15% responsible, maybe 20. This pendulum has shifted. And now municipalities are being held responsible 66 2/3 or 100% responsible. So courts are apportioning more to the municipality and less to the individual. So that's a lack of contributory negligence. We've seen some very upsetting, disturbing decisions. Bruce County was one of them. This was a decision where, long story short, gentleman on a bike in a bike park area before a recreational trail, took his mountain bike and went on a bike feature. It was a teeter-totter type of feature. went up on his bike, didn't have enough speed, fell off to didn't have enough speed to go over that fulcrum of it, fell off, became a paraplegic in front of his 2 kids and wife. There was signage posted. This was a recreational activity that they were voluntarily participating in. They had even looked at the area the day before, gone out and made sure everyone had helmets. And Bruce County was apportioned 100% responsibility for that. So that man who chose to get on his bike, who chose to try these features, who had read the signage, who knew enough to wear a helmet, absolutely no contributory negligence, no responsibility on his part. To me, this has been a very, very scary trend in municipal claims and municipal decisions. Escalating cost of claims is also something that we talk about a lot. We talk about how damage awards have just risen and risen. $5 million 10 years ago, and all of a sudden it's 15 million. Why have they gone up so exponentially? It's because of the future care costs. This is what I often describe as that double-edged sword. We are so fortunate to live in Canada, so fortunate to be in Ontario, where we have access to phenomenal medical care. But those medical advancements mean that we are keeping catastrophically injured persons alive longer, and we are able to do more for them. Instead of sending people to a home to live after becoming catastrophically injured, we are setting up essentially mini care homes at their houses. So we are sending in nurses for 24/7 care. And, it's not a regular nurse like, 30 years ago for $25 an hour. It's a brain injury specialist nurse that's $55 an hour. We're seeing a huge increase in these brain damage cases. And, it's not because there's actually more head injuries or more concussions. It's because we know more about them. We know the dangerous effects that concussions can have, and our medical care has adjusted as such and have specialists for these areas. Now, again, if this was your loved one, of course, you would want everything possible for them. Take advantage, make sure that they have a home that's retrofitted to meet all of their needs. But that is a very expensive endeavor. For a couple of examples to give you an idea, Frank Cowan Company handled a claim where a teenager was catastrophically injured when hit by a car at an intersection. The case was settled midway through trial for over $8 million. Future Care accounted for $5 million of that settlement. In McNeil and Bryant, the court awarded over $18 million. This was a judgment for a 15-year-old female who received a severe head injury, again, as a result of a motor vehicle accident. Of that over 18 million, over 15 million of that award was for Future Care alone. And there are lots more examples of those rising costs. So you must be saying to yourself, well, Jess, like you said, we've talked about this numerous times before. What's changed? I'm facing double-digit insurance increases. Our municipality is struggling with these rising insurance costs that we're experiencing. So what else is going on? Why is this happening? Unfortunately, there are a rise in the number of factors that are impacting municipal claims. Factors that are driving up claims, which in turn is driving up the cost of insurance. The first one that we have to talk about is property losses. Property and climate change. This is a huge issue right now. Climate change has resulted in a substantial increase in property losses and catastrophic losses, what we call CAT losses. Regardless of whether this has impacted a municipality directly, the substantial escalation worldwide has increased both property insurance and reinsurance rates across the world. Even accessing adequate property capacity is becoming increasingly harder all across Canada. According to Munich Re, overall losses from worldwide natural catastrophes or CAT losses in 2020 totaled $270 billion. This is the fourth highest level in almost 4 decades. Canada's total was $2.4 billion, our fourth highest year on record. Canada is not immune to these catastrophic property losses. There were 6 severe weather events in Canada in 2020. These included rain, hail, snow, windstorms, and flooding. The 2016 Fort McMurray wildfire event was the single largest cat loss in Canadian history. Prior to Fort McMurray, the largest single cat loss event were the Alberta floods in 2013. 8 of the top 10 highest loss years on record occurred in the last decade, the last 10 years. Simply put, property and property reinsurance rates are on the rise. Cyber. Who hasn't been affected or talked about cyber? It is a huge issue. Cyber claims have risen dramatically in the last 3 years, and it is anticipated that these claims will grow at an exponential rate. In 2018, a number of small Ontario municipalities reported cyber attacks. One recent attack in the US resulted in a hacker gaining access to a municipal water system. In 2020, a Western Canadian municipality fell victim to a $1 million phishing scheme, while an Atlantic Canadian municipality had to spend 4 to 6 months restoring their computer system as a result of the hack. And we've all seen the news recently with the latest hack on the US pipelines. Transit. I don't think I've ever spoken at a conference when talking about, municipal claims and claim issues about transit, but today I have to. Transit claims are increasing in severity. Operating a transit system we know has inherent exposures attached. When buses have accidents, claims can be filed by all the passengers in that bus, resulting in extremely significant awards. Recent transit claims have put a tremendous pressure on auto policy premiums, pressures that I'm sure that your municipality has seen in your transit renewals. Class action lawsuits are also increasing in frequency. Canadian courts are more willing to certify class actions, and more lawyers are pursuing them. Even when a municipality may be innocent of the allegations, class actions are much more difficult and costly to defend. And I think this is an important point to highlight. So for example, a recent class action claim commenced against a municipality for breach of privacy. It had 85,000 potential claimants as per the proceedings. Through the legal process, it was finally determined that there were only about 40 legitimate claimants. After careful review of all the submissions, the claim was settled. All but one of the claims were rejected for a total damage payout of $113. Third-party legal costs, defense costs, and expenses totaled well over $1 million. Judgment award, just over $100. The legal costs, well over $1 million. Now, when we talk about class actions right now, we can't not talk about COVID-19. COVID-19 claims have triggered a number of class action suits for municipalities. Now, although many provinces, including Ontario, have put protections in place, ultimately it's going to be the courts that determine the outcome of these actions. Bill 218 is what Ontario has done to help protect. So in November, the government passed Bill 218 into law, raising the level of negligence that must be proven for a plaintiff to make a claim against a defendant for COVID-related issues. This was in response to claims that were being posed against some long-term care homes and other businesses and public entities. The legislation shut down claims that alleged negligence as the cause of COVID outbreak at a premises. Instead, the plaintiff must allege that the defendant's gross negligence directly caused the COVID outbreak. Interestingly, this legislation applies retroactively to March 17th of last year. Now, the fear is, although we have and are very grateful for this protection of Bill 218, a lawyer who's now had that negligence claim struck, so it's no longer valid, can take that statement of claim and wherever they wrote the word negligence, now put gross negligence. And why not? Because honestly, they're going to try and test it. They're going to allege gross negligence instead of just alleging negligence. Will it be harder? Yes, but will they still try? Of course they will. And those of you who deal with other types of municipal claims, including winter sidewalk claims, can relate that Gross negligence is not defined in legislation. The only other place for municipality that we see the term gross negligence is in Section 44 of the Municipal Act, way down in subsection 9 of Section 44, that mentions gross negligence, which must be shown for a claim of personal injury for snow or ice on a sidewalk. When we talk about winter sidewalk claims, we talk about how difficult it is because there's no set definition of gross negligence. I think we'll find the same issue here. Gross negligence is very bad negligence. Again, no set definition or term in the legislation. Now, I haven't spoken about this before with everyone, but I would be remiss if I didn't talk about it quickly today, and that is the insurance cycle. The insurance itself is a cyclical business. It has been historically defined as being either a hard or a soft market. A soft market typically exhibits low rates, generous terms, abundance of capital, and more competition. Whereas a hard market, the opposite, higher rates, restrictive terms, reduced levels of capital, and less competition. The insurance cycle impacts all lines of business: property, liability, auto. Over the past 5 decades, there have been about 4 hard markets. One in the mid-70s, another in the mid-80s, early 2000s, and we're in one right now. It's been 15 years since the last hard market, and consensus was that we were likely overdue. One consistent observation is that the hard market is usually short in duration, around 3 years. A soft market usually lasts much longer, the last one being about 15 years. It's difficult to predict when the hard market will end, but insurance professionals expect it to continue well into 2020. This means, unfortunately, double-digit premiums for many. This will continue 2020 throughout 2021. Property capacity is challenging, especially for municipalities with large property schedules. In certain cases, restrictive terms have been applied. In addition, competition is reduced. Municipalities in the past usually have 3-4 bidders on an RFP. Over the past year, we've seen that level of participation decline. And in some cases, there's been only 1 bidder, maybe 2. Now, what can municipalities do? I think that municipalities need to focus on what they can control. Work on your risk management, work on your education and training, and think of insurance as not just a commodity, but as a service. Ask your insurer questions. Ask how they manage claims. Ask their cycle of claims time. Ask if they have resources that you can use, whether that's education and training or certain services that can be of use for a municipality. We know that good risk management is no longer an option for our municipalities. We know that it is necessary. And unfortunately, during these times when we're in this hard market and we're facing these insurance premiums, there are certain things that we absolutely cannot control, like the weather, like those cat losses. We can't control the court's rulings right now. So let's work on things together that we can control. Let's work on risk management, and let's see how we can improve our losses and our ability to rebound from those losses together. I'd like to thank everyone for listening to me today, and I hope you enjoy the rest of the conference. And feel free to contact me anytime at Intact Public Entities. Thanks, everyone.